training on civil litigation, and your topic, like I said, is preliminary, simple, straight to the point. If I were you, I would have started by, when you're talking about sources of civil litigation, I would have started by discussing the laws. What are rules? What is the status of a rule or rules of court? Yeah, subsidiary legislation, simple. If you had heard me, I said if I were you, I would start with law. You know, laws are the organic structures of the regulation. They are the basic principal laws, whereas the rules are subsidiary legislation. The rules and the practice directions are subsidiary legislation. So when we want to talk about sources of civil litigation, starting with laws, we want to first of all look at the ground on constitution. And my question is, how is the constitution a source of civil litigation? Answer it.
The rules of court and every other civil litigation draws its strength or source from the constitution. That is how the constitution
No, they are coming close.
That is how the constitution forms its.
Okay, every other rules draw life from the constitution. How? You're getting close, right?
The constitution has set out principles through which those rules
in making the rules, giving the authority to the bodies that can, or persons that can make the rules through its various provisions. That is one point. Next point, how is the constitution a source of civil litigation?
This is because
you know, I'm asking this. You see it in the exam. People write constitution is a ground of blah. You're not writing constitutional law. You have to be specific. Link it to my question.
This is because the court is a creation of the constitution and also enables the authorities to make such other rules that govern this court.
So what's the business of the court with civil litigation?
To hear and determine matters.
Because that is the forum that hears and determines matters of
Disputes.
and the constitution has created those courts. 2 points. Next point. You understand what we're doing now? Right. Next point.
It's the source of civil litigation in the sense that it makes provision for the jurisdiction of the court and the civil rights of.
So how does it make a provision for jurisdiction of the court?
For example, certain sections of the Constitution provides for jurisdiction of the courts according to their.
It has created courts and donated them with jurisdictions. Good, I agree with that one. Then the next thing I want you to tell me, now that you're on jurisdiction, what else has the Constitution done about jurisdiction? It has created court, I agree. Let me also help you. Section 6 created access to court. Now, what else has the Constitution done about jurisdiction? Go on.
Okay, the constitution also tried to specify the matters which this court.
Subject matter jurisdiction. Next. Are you understanding me? Yes, in creating of courts, it has created courts, created access to court, and it has also created subject matter jurisdiction per court. What next? Still on jurisdiction. What next? By implication, territorial jurisdiction also derives its source from the Constitution. What next?
Jurisdiction as the constitution of the judges. That is the number.
Jurisdiction in personam. Correct. What next? Appellate jurisdiction. Right. Okay, and now we'll go over to other laws. How are other laws sources of civil litigation? Let's brainstorm on that. We are done with the Constitution now. There could be a lot of other things. We're talking about other statutes or other laws forming sources of civil litigation in Nigeria. So how does that happen? For instance, if I say Evidence Act is one of those laws. So, okay, you're done with evidence. Good. How is Evidence Act, a source of civil litigation?
The Evidence Act is a source of civil litigation because it helps in highlighting procedures at which, when it comes to civil matters, the procedures for adducing evidence, the procedures for accepting evidence, the procedures for cross-examining witnesses and so forth. So in terms of highlighting how court proceedings according to civil litigation and to operate, the act serves as a source of civil.
I agree with you. Now, this Evidence Act, does it operate on its own or does it draw life from the Constitution?
The Evidence Act draws life from the Constitution.
How?
Because the Constitution creates courts that have jurisdiction to entertain civil litigation matters. That, by implication, in terms of civil matters and civil engagement, every other law that has to do with that particular engagement derives its authority from the Constitution in that particular engagement, as empowered that particular.
I'm talking about Constitution. Has it mentioned evidence? Has the Constitution mentioned evidence? I want to link it now. Okay.
I said, if you look at part 1 of the Constitution, under the specific list,
Part 1, which schedule? Part 1, second schedule of the Constitution, precisely item 23 is evidence. So that means evidence falls within the exclusive legislative list. So it has drawn life from the Constitution. So whatever it does now, it expands, and then that shows is a source of civil litigation because it tells us rules of admissibility. It talks about facts. When facts are relevant, when facts are an issue, how to adduce, how to make inference, how to presume. What can we, adduce? Direct evidence, circumstantial evidence, hearsay evidence within the scope of the exceptions. Right. Any other law that has formed a source of civil litigation?
so the Companies and Allied Matters Act.
Okay.
Then the company winding up rules and then the company procedure rules. And now we know that matters involving companies and all those things that fall under civil proceeding. So that rule has also eliminated. And so it creates an enabling law for civil. Also, there's also the Foreign Judgment Enforcement Reciprocal Act, and that talks about how foreign judgment are to be enforced. Now, if it involves civil procedure, that act now forms a part of our civil procedure.
Okay. Can we talk of any other law?
So another law is the Matrimonial Justice Act, which actually talks about how you can contract marriages as well as those marriages in sort of instituting a petition.
Does it actually tell us how to contract marriages?
It goes further to debate the age limits and then the form certificates and then
So that is how now. So why were you confused? That I asked you a question doesn't mean you were wrong. I just wanted you to be sure what you are saying. Okay.
So for the fact that marriage, issues of marriage petition and the rest is a civil action.
Okay.
So the Act has already provided a background for the course of action as well as the jurisdiction of the court that can attend to those matters.
Okay, thank you very much. So every law has something to do with civil litigation. Every law. If you talk about Custom and Exercise Act, they will tell you if you do this, it constitutes a crime. If you do this, you evade, it becomes unlawful. And that the court with jurisdiction is, it will tell you. So that means every law. And the Police Act also the same thing. Police talks about arraigning somebody in court. Though that one more or less is what is criminal in nature. But the admixture of the civil there is when you're talking about giving the right of the suspect. The suspect has right. And his rights are contained where? In the Constitution. The suspect has constitutional rights to fair hearing, right of interpretation, right of information, telling him what the offense is all about. So we also come to that. Then the next thing I want to look at now, rules. Just like the group said, every court has its own rules. Now, simple question. What are the duties or the purposes of rules of court?
Rules of court help guiding court proceedings and also in terms of how
Even the way it sounds, the rules of court, those are the rules, the guideline, it guides the court. And that's why the law says that rules are handmaids of the court. They are handmaids. Who is a handmaid? A guide. A guide. You know, a guide, you can even turn it to present it as a servant. That's why the Supreme Court says that the rule is the servant of the court, and so the court cannot be slavish to its rules. That's why most of the times the rules of court will make rules, and you now talk about non-compliance. And in discussing non-compliance, it will tell you that certain non-compliance will be treated as what? Mere irregularity. But when those non-compliance are procedural and fundamental in nature, that's when they go to the root of the action already instituted. Right. So they are handmaids of the court. There are some of the non-compliance with the rules that will not void your action. Why is it like that? It's because the rules are just there to guide the court. The court is not there to be guided by the rules, but for the rules to do what? To guide by. In other words, the court is not a slave to its rule, so that it creates a level of flexibility, so that the court can do what? Bend its rules. There is this matter, and then judgment was given against the other party. In the notice of appeal, one of the things that conversing was that my lord did not give judgment within 1 year as against the stipulated 90 days. And you know, you read it, it sounds beautiful. It sounds laudable. You understand? But then that 90 days is not sacrosanct. It depends on whether the party complaining has suffered any miscarriage of justice. And of course, the Constitution itself says that non-compliance with that 90 days rule will not invalidate the judgment of the court, except you can show that much delay derailed the thought pattern of the judge. And at the time the judge was writing judgment, maybe instead of calling Job, my lord was calling Mary and crediting Job's evidence to that of Mary. That we can say there's a prejudice. So that's talking about the rules. And we have also talked about the authorities that can make rules of court. And then another thing, the practice direction. Just like the person that has the right to make rules of court can also do what? Make practice direction. What is the essence of practice direction? Practice direction at times are made to cure some, bridge some lacuna, fill in some gaps. For instance, I remember when I did a murder case, and then we challenged the purported confessional statement, and we were subjected to trial for die. That's trial within trial. So at the time of trial within trial, I knew that I had created an atmosphere of confusion. So I applied to my lord that it would be better for my lord to consider his ruling at the end of the matter. Why? Because it was obvious that if my lord had given ruling in my favor, that case would have died then. Do you understand? So because of that, my lord found this is a good opinion, and he came out with the practice direction, which we're still practicing till today. In other words, what the practice direction did was to build a bridge between the law, the rules, and the practice. So if, for instance, in the rules of court, there is maybe in the past there was a particular time where the rule was that you can apply for extension of time if you fail to file your process within time, but that every day of such default would attract 1,000 naira. Now check when a lawyer, being dialectical, fails to file his process for about 2 years or so, who do you collect the money from? Is it from the lawyer or the client? So because of that, we now started attacking the rules. And my lord made a practice direction, reducing it to 200 naira, which has gone into the new rule as the amount to be paid when you are applying for extension of time. Now, the second aspect of the question asks 6 questions on this scope of civil litigation. You know, when we talk about civil litigation, generally speaking, civil litigation deals with rights and obligations, or liabilities, which are in dispute. Now, these rights and obligations can arise from any subject matter, be it contract, land, insurance, maritime, banking, and so on and so forth. So, this is where we need to look at the scope of civil litigation. And suffice it to say that anything that has not fallen within the purview of criminal litigation is what? Civil. So that's just the thing. If, for instance, because I knew a time, like the course I'm teaching at the PG level now, there was a time there was no course known as that. Secured credit transaction. You know. So now that that course has been created, it has become a part of what? Civil litigation. There was a time too that we did not have consumer protection in Nigeria. You discover that the scope of civil litigation is very, very wide. But we can just like look at a few of them, like the group has stated. Alternative dispute resolution is like when somebody is making a statement. Instead of going to court, why don't you adopt alternative dispute resolution? And then you ask me how, and he start telling you types. You understand what constitutes alternative dispute resolution. So there is no mode of action or settlement known as ADR. No. ADR is just like a shell. The shell is not the matter. What is the matter is the content. So inside ADR, you now have arbitration. Arbitration, which simply means party autonomy. If I'm having a dispute with you, we can agree. There are two means of arbitration. Either we agree to subject our dispute to an arbitrator or arbitration institution. Or while we are making our agreement, our contract, we could make a provision in the contract. It could be a provision in the nature of Scott and Avery clause. It can even be a provision in the nature of the Atlantic clause, which simply means the clause may read, in case of any dispute arising from this contract, parties shall refer to a two-man arbitration panel, each to be appointed by each of the parties. And then another one could be couched this way: in case of dispute arising from this contract, the parties must first refer or submit to an arbitration of two-man panel, each to be appointed by each of the parties hereto. Which of them is compulsory in nature? Which of these two clauses? Which one? The second one, not the shall. Both of them have shall. But when the first one says it just permits it. If we have dispute, we can go to an arbitration. This other one says if we have dispute, we must first of all submit to an arbitration. So the second one is compulsory in nature, and that is what is called arbitration clause. The other one is arbitration clause, but it's not strong enough. So if a contract has a real arbitration clause that has made arbitration a condition precedent for litigation, it simply means we must first of all do what? Try our luck there. When it doesn't work out, we cannot come back. But if we have that compulsory clause and the other party sued me without going through the process, can I have the suit struck out in court? The only remedy is what? Stay of proceedings. You have filed a suit against me in a contract that has arbitration clause. I simply come to the court and file a motion and say, my lord, he has not complied with condition precedent. The suit will not be struck out. Do you understand? We simply do what? Refer to the arbitration panel. And most of the times, when you submit, there is submission to arbitration panel. You can submit conditionally or unconditionally. When you submit unconditionally to arbitration panel, then that means you're not going back to the court. Why? Because the award, decision of an arbitration is called what? That award becomes what? Final and binding, just like judgment of the court. All right. Then we have negotiation. We say, man, why can't we just sit down and talk about this? Instead of going to court, we can do that ourselves. We can bring in our friend. That doesn't mean arbitration. And there are some judges too that misapply arbitration. If a matter is going on in court, I'm now talking about conciliation now, and partly mediation. If a matter is going on in court and my traditional ruler comes and tells the court that he wants to try his hand in settling this case, we allow him. My traditional ruler would be wrong to take us to his palace and say, you state your case. You state your case. You're guilty. You are liable. That would be wrong. What is he doing? Customary litigation, which is not the same thing as what? Arbitration. Arbitration simply means you've got to lose something, I've got to lose something. You win and win. 50-50. A win-win situation. So if there is nothing like that, then it is not what? Arbitration. So because some of the time people misunderstand conciliation. Conciliation is a settlement, settle these people. When you settle them, okay, you have incurred loss, and let this go this way, let this go this way. So that in the end, everybody is happy. Mediation, the same thing. The only thing about conciliation is that most of the time it's statutory. It's governed by law. Just like arbitration and Conciliation Act 1. Two things put into a single act, 2004. Do you understand? But mediation is just a means. Anybody can involve in mediation. You can train to be a mediator. So, and then also within this fulcrum, we talk about matrimonial courses. Matrimonial courses basically talks about matrimonial reliefs. For instance, divorce. Anytime somebody talks about matrimonial reliefs, it's not just divorce. That is a way of settling matrimonial dispute. Under matrimonial relief, we also have separation apart from divorce. You may just separate, let the nerves calm. Not that when one other man said that he accepted separation, the next time he said, "My Lord, I accepted." Because his case was that the wife was just a troublesome woman. When the separation was proposed, at the cost of the man, parties agreed, and the man came back the next time. I said, "My Lord, the fact that I accepted separation does not mean that she will be back on her shower." And my Lord said, "You don't use that kind of plan." He said, "But my Lord, I'm saying the truth." So separation is not for you to make the matter worse, right? Separation is to see if the nerves, except if the marriage has become an empty shell. When the marriage has become an empty shell, that's when you know there is no going back. There could also be a jactation of marriage. Jactation follows a successful plea of divorce. It simply means don't answer my name any longer. You understand? We also have an election petition falling within this scope. Recovery of premises. Election petition simply means the right to challenge the outcome of an election result. Either you are challenging it on the ground that the party who was declared as the winner of the election was not qualified as at the time he contested the election, or that he was not the party that scored the majority of the total vote cast, or that, what again, the election was marred by irregularity. There is another ground that has been removed by the 2022 Act, and that's the ground that talks about that I was selected but unlawfully disqualified. So they have pushed that one to pre-election relief. We also have a recovery of premises. Your landlord wants you to quit. What steps can he take? Not only that, recovery of premises also entails maybe a place that you have licensed to somebody. You have licensed a petrol station. You have even licensed maybe your warehouse to someone, or you have brought in somebody to use for the use of an occupation of that place, not necessarily paying you rent. When you want to evict him, what do you do? So that's what recovery of premises is all about. You can also talk about mortgage transactions. If a mortgage has been executed, a mortgage deed, and at the point of realization of the mortgage sum, the mortgagee and the mortgagor is not yet forthcoming. He has defaulted. What do you do? Do you sell the property that has been mortgaged, or what do you do? At times, you also have problem when that property has been encumbered. What also happens in leases, when you have leased, not tenancy now, when you have leased a premises for a determined period of time, and at the fluctuation of time you want to recover, what do you do? So that's what this law talks about.